Welcome to the third module titled LGBTIQ People in Prisons Experiences of Discrimination, Stigma, and Isolation. This module contains the following issues: needs and challenges faced by LGBTIQ people in prisons, specific psychosocial needs of LGBTIQ people in prisons, LGBTIQ people experiences in prisons, international legal standards and good practices for the treatment and management of LGBTIQ inmates. This module, titled LGBTIQ People in Prisons Experiences of Discrimination, Stigma, and Isolation, is comprised of data and findings from studies and official reports on the experiences of the specific group of inmates, examples of successful policies from other agencies, and relevant court decisions. The objectives of this module is for prison staff to understand the potential needs, barriers, obstacles, discrimination, stigma, etc. LGBTIQ people in prisons have experienced while incarcerated, to improve their understanding of risk situations faced by LGBTI persons deprived of liberty with the aim of enhancing their protection and adequately meeting their needs, to foster a mindset sensitive to issues related to sexual orientation, gender identity, gender expression, and sex characteristics, to become aware of the issue and to contribute to ending stigma and stopping cycles of discrimination and violence, to understand the existing good practices in the field of treating and managing LGBTQI persons deprived of liberty and contemplate on the ways to apply them in their settings. LGBTIQ individuals, encompassing lesbian, gay, bisexual, intersex, queer, and transgender persons, are a particularly vulnerable demographic within the criminal justice system and prison environments. There has been limited discussion about their specific requirements so far, despite a growing body of information shedding light on the discrimination and mistreatment experienced by this community in criminal justice systems globally. In the context of the criminal justice system, discriminatory attitudes towards LGBT persons can manifest in several ways. For instance, they may be perceived as less credible by law enforcement agencies due to societal biases and prejudices. Amnesty International, 2020. As a result, they might not receive an equal standard of protection under the law. In prison, such groups may often be discriminated against and suffer humiliation, violence, and sexual abuse. Most jurisdictions have limited or no policy to guide prison management and prison personnel in relation to the special needs of LGBTIQ prisoners. LGBTQ+ individuals experience a disturbing reality behind bars. Incarcerated sexual and gender minorities face sexual victimization at significantly higher rates compared to other inmates. The prejudice and social isolation they often encounter in society are amplified within correctional facilities. Some alarming statistics: gay and homosexual men face a much greater risk, 11 and 10 times, respectively, of sexual assault by inmates compared to heterosexual men. Bisexual women are more likely to be sexually assaulted by inmates than heterosexual or lesbian inmates. Bisexual and lesbian women, along with transgender individuals, 15% as per a national survey, experience higher rates of sexual assault by prison staff. Intersex prisoners face additional trauma from voyeuristic strip searches and sexual harassment by staff and inmates. The significant vulnerability of LGBTIQ persons in the criminal justice system in many counties calls for thorough research on the needs of this group, so that further steps are taken to ensure that they are not discriminated against in their access to justice and victimized in the criminal justice system due to their sexual orientation or gender identity. The basic needs and challenges members of this group experience can be summarized as follows. 1. Access to justice. LGBTIQ persons, when arrested for an alleged offense or when lodging a complaint of harassment by third parties, may be subjected to further victimization by the police, including verbal, physical, and sexual assault and rape. If such offenders wish to complain about their treatment by law enforcement officials, their complaints may go unheeded, or they may even face retaliation, which would discourage them from seeking justice unless assisted by suitable legal counsel. Discriminatory attitudes may affect decisions relating to pretrial detention and prison sentences. If held in pretrial detention or prison, their access to lawyers and legal aid may be problematic in many systems due to the unwillingness of prison staff to assist, based on deeply rooted prejudices. 2. Protection needs. The main and most important need of LGBTIQ inmates is protection from sexual abuse and rape, generally perpetrated by other prisoners. LGBTQ inmates are highly overrepresented as victims of sexual assault and rape. One study in the United States, for example, found that 41% of gay and bisexual men were sexually assaulted in prisons, as opposed to 9% of heterosexual men. Sometimes prison staff themselves facilitate sexual violence in return for bribes. There are reports of prison guards having LGBTQ inmates beaten up or allowing other prisoners to rape them, and of prison staff placing LGBTQ inmates in cells with known sexual predators. There are also reports of prison staff running prostitution rings, where all transgender prisoners are forced to participate. In some prison systems, prisoners who have been victims of rape are regarded and labeled as homosexuals and treated as the lowest group in the prison hierarchy, both by the prison administration and by other prisoners. They may routinely be held in separate dormitories and eat at a separate table in the prison dining rooms. They may be used to undertake the most menial tasks in prisons, both by prison staff and other prisoners, and are at risk of being victims of sexual assault and rape. 3. Complaints procedures. In many prison systems, complaints about sexual abuse and rape in general receive no or little response from prison administrations, and especially if such complaints are made by LGBT prisoners. It has been reported, for example, that when complaints of rape are made by gay prisoners, staff often allege that the act was consensual, implying that gay prisoners invite sex. In addition, prisoners themselves are very reluctant to complain due to fears of retaliation, often as a result of open threats by the perpetrators against reporting. When complaints are acted upon, and for example the prisoner separated from the aggressor or the aggressor punished, the stigma of having been raped remains with the prisoner, and the information spreads rapidly in the prison system. The victim is therefore at risk of further victimization, unless he or she is provided with adequate and constant protection. 4. Healthcare. LGBT offenders are more likely to suffer from STDs, including HIV/AIDS, problems associated with drug abuse, and other health conditions, since often they will have been forced into a lifestyle that includes risk behaviors because of prejudices relating to their sexual orientation or gender identity. Prison rape is also responsible for the spread of HIV/AIDS. With LGBT prisoners being the most likely victims of rape, they are at high risk of acquiring HIV/AIDS in prisons. LGBT persons who have been raped in prisons may receive inadequate or no medical treatment for the injuries resulting from the sexual violence on grounds of their sexual orientation or gender identity. LGBT prisoners are likely to be in need of psychological support and mental health care, particularly if they have been sexually abused, whether prior to imprisonment or in prison. Even if not sexually abused, the discriminatory attitudes and humiliation they are likely to be subjected to in prisons will require particular psychological support and programs to treat the mental distress suffered as a result. LGBT prisoners who have been victims of rape may be at risk of self-harm or suicide, for which they will require special supervision and care. 5. Allocation, accommodation, and inmates programs. LGBT prisoners may be placed in conditions which are inferior to that of the majority population. Moreover, in prison systems where no proper classification exists and where overcrowding is the norm, LGBT prisoners may be placed in dormitories or cells together with prisoners with a violent background, including with a history of sexual abuse. There are many reports of sexual violence suffered by LGBT prisoners by other prisoners due to lack of care taken in their placement. There are reports of victims resorting to breaking prison rules on a regular basis in order to be put in administrative segregation for prolonged periods, purely to escape from the sexual abuse and rape suffered in dormitories or cells, underlining prisoners' need for protection as a priority, even if this means isolation. Finally, LGBT prisoners may be discriminated against in receiving access to activities, or they might themselves not want to participate in prisoner activities, due to the risk of violence from other prisoners. 6. LGBT and especially transgender prisoners are likely to have very limited or no contacts with parents and other family members due to their sexual orientation or gender identity. As same-sex marriages are against the law in many countries around the world, they are also unlikely to have a lawfully wedded spouse, which would exclude the possibility of receiving visits from their partners in many prison systems. In some systems, where conjugal visits are allowed to unwed partners, LGBT prisoners do not enjoy the same rights. Thus, In many jurisdictions, LGBT prisoners' contact with their families and partners may be extremely limited, exacerbating the sense of isolation in prison, impacting on their mental health condition and social reintegration prospects. 7. Preparation for release. LGBT prisoners are likely to have special needs in preparing for release and support during the post-release period, due to the lack of family contact, possible traumatic experiences in prison, and lack of adequate support mechanisms for such groups in the community, particularly for those who have a criminal record. Apart from these needs and challenges, according to a recent study titled Views and Experiences of LGBTQ+ People in Prison Regarding Their Psychosocial Needs, a systematic review of the qualitative research evidence, published in 2021, extra factors were mentioned to summarize the needs among the population of LGBTQI+ inmates as follows. 1. Disclosure. There are many reasons that LGBTQ+ people may choose not to disclose their gender identity or sexual orientation whilst in prison, due to the threat of transphobia, homophobia, and biphobia. Many people feel discriminated against, stigmatized, threatened, and may encounter physical or sexual violence or abuse. The process of coming out, being out, and staying out was problematic and depended very much on the context and the audience. Disclosure, if evident, was measured and carefully and safely revealed. This often led to hypervigilance and increased stress and anxiety. 2. Poor mental health. Prisons remain heteronormative environments and are not conducive or responsive to the issues and concerns of LGBTQ+ prisoners. As a consequence, the psychosocial needs of this population are left ignored, hidden, and unmet. For instance, there are significantly higher incidences of depression, anxiety, and suicidality compared with the non-LGBTQ+ population. There is evidence that homophobia is ubiquitous in men's prisons as a result of a corrections culture of pronounced masculinity and rigid hierarchy, often supported through violent means. Significant numbers of male prisoners can demonstrate higher homophobic disapproval than those in the general population. These attitudes and behaviors can also be mirrored among staff in many prisons. This can result in the degradation, devaluing, and victimization of LGBTQ+ prisoners who are not perceived as being masculine enough. Need to specific training and education for prison staff on the needs of LGBTQ+ people and specific issues relating to the subpopulations of this group. Failure to recognize and address the specific and distinct needs of LGBTQ+ populations lead to their further marginalization and discrimination, which impacts on their often already poor health. According to a recent report titled LGBT+ People in Prisons, Experiences in England and Scotland, published in 2020, the research, based on interviews with LGBTQ+ inmates and prison staff, highlighted the following themes and experiences. 1. Lack of support. LGBT+ participants reported a lack of access to appropriate support related to being LGBT+, which led to people feeling isolated, misunderstood, and mistrustful towards the justice system. The system was perceived as inflexible and uncompromising. Respondents felt that they are doubly disadvantaged by lack of staff knowledge and understanding around LGBT+ issues, and lack of knowledge and understanding regarding their own rights. 2. Barriers to more inclusive practices. Overall, individual and institutional barriers exist that make being LGBT+ in prison particularly difficult. In many cases, this adds to an already negative experience. Among these are practices and attitudes that value masculinity and being heterosexual. As part of both institutional and individual mindsets, these tend to be overlooked and normalized in the functioning of the prison environment. These can be difficult to tackle as they are pervasive and, in many ways, invisible. 3. Segregation and institutional discrimination. Homophobia, biphobia, transphobia, and explicit violence directed at LGBT+ people in custody is often dealt with by segregating the affected individual for their own protection. English and Scottish prisons often use the same physical spaces for disciplinary and protective segregation. The segregation units have particular routines and limitations on space and freedom, with the result that people being segregated for administrative reasons do not have substantially different experiences of these spaces than those who have been segregated for punitive reasons. 4. Concerns about disclosing sexual orientation and gender identity. Some people in custody report that they were not open about their gender identity and sexual orientation due to fears of discrimination or abuse. This influences the way they engage with others. At times, LGBT+ people in custody are selective about whether to disclose their identities or not. This creates emotional distress through a lack of trust towards both peers and staff, and a fear of violence. Now, let's take a look on some good practices at global level regarding the treatment and management of LGBTI persons deprived of their liberty. Click on the maps to find out more. The first example of a good practice: targeted visits by civil society organizations to examine the situation of LGBTI detainees. In Ireland, the Irish Penal Reform Trust, IPRT, conducted a small-scale Chapter 2 exploratory study on the rights, needs, and experiences of LGBT people in prison. The report, the first in-depth study on the experiences of LGBT prisoners in Ireland, includes first-hand testimonies by LGBT prisoners and a review of the prison and policy context. The study included interviews with 7 LGBT detainees or former detainees, 10 stakeholders from the criminal justice system, and 4 representatives from the LGBT community. The authors were well aware of the ethical challenges of outing detainees while conducting the investigation and took measures to mitigate such risks. The measures included submitting the project for review to a research ethics committee and to the Irish Prison Service, making arrangements to safeguard the anonymity of participating detainees, including in respect of designated personnel within the prison service, providing each participant with information about the project during face-to-face meetings, where the parameters of confidentiality were explained, having interviewees sign a consent form, using pseudonyms for all persons in the report, and not disclosing the name of the prisons in which the interviews and focus group took place. The second example of good practice: NPM visits and thematic reports focusing on the situation of LGBTI detainees. Following a visit to the prison of Gorizia in northeast Italy, the Italian NPM, Garanti Nazionale dei Diritti del Persone Detenute o Private della Libertà Personale, published a visit report highlighting the specific situation of gay and trans detainees. The visit was prompted by specific circumstances following the opening of a special unit for gay detainees in September 2015. The unit was equipped to host up to 17 detainees coming from various prisons of the region. In its report, the NPM was critical of the unit for various reasons. First, and while recognizing that the authorities had consulted with NGOs working on LGBTI issues ahead of opening the unit, the NPM expressed concern about the risk of further isolation and stigmatization of gay detainees, who were in danger of being held in a world apart. The NPM was also very critical of the fact that one detainee had remained in a situation of de facto solitary confinement for 2.5 months. In its report, the NPM recommended the undertaking of a review of the policy that led to the establishment of such a unit, with the aim of providing equal treatment and conditions for all detainees, and suggested the establishment of a working group to identify ways forward. As a result, the Ministry of Justice decided to close the unit and to allocate gay detainees to other prisons in the region. The report helped bring visibility to the issue and was echoed in NGO statements and the media. The third example of good practice: the Prison Rape Elimination Act, PREA, and PREA Standards, USA. The Prison Rape Elimination Act, PREA, was passed in 2003 with unanimous support by the United States Congress. Its purpose is to provide for the analysis of the incidence and effects of prison rape in federal, state, and local institutions, and to provide information, resources, recommendations, and funding to protect individuals from prison rape. The act led to the creation of the National Prison Rape Elimination Commission, which was charged with developing draft standards for the elimination of prison rape. The PREA Prisons and Jail Standards, published in 2012, include provisions that direct government agencies to pay particular attention to the need to protect LGBTI persons. Among other things, the standards stipulate that the assessment of detainees during an intake screening and upon transfer to another facility for their risk of being sexually abused by other inmates or sexually abusive toward other inmates consider whether the inmate is or is perceived to be gay, lesbian, bisexual, transgender, intersex, or gender nonconforming. The standards also provide that protective custody must be limited in time and not entail the imposition of a harsher prison regime, and contemplate disciplinary sanctions both for staff, including termination, and for fellow inmates who violate agency's sexual abuse or sexual harassment policies. The fourth example of good practice: prison policies for the allocation of LGBT detainees. In the UK, Prison Service Instruction 17/201656, the care and management of transgender offenders, came into force in January 2017. According to this instruction issued by the National Offenders Management Service, which replaced an outdated policy from 2011, arrangements must be in place to determine the legal sex of all offenders during the initial assessment. During this initial point of contact, trans detainees must be asked their views on which part of the prison estate best reflects the gender with which they identify. Where a trans detainee wishes to be allocated in part of the prison estate that is not in accordance with their legal sex, the decision is made via a local transgender case board, on a case-by-case basis. This new policy deliberately uses the term transgender rather than transsexual and acknowledges that some offenders may have a more fluid or neutral approach to their gender identity. The fifth good example of good practice: policies on searching trans detainees and policies and regulations banning discriminatory sanctions stemming from homophobia or transphobia. Colombia's General Regulation on Correctional Establishments aims to protect the rights of LGBTI detainees. It grants them agency in body searches by allowing them to choose the searcher's gender, male or female, on a case-by-case basis. Similarly, trans visitors are searched based on their self-declared gender, not ID information. Furthermore, the regulation prohibits discriminatory sanctions based on sexual orientation or gender identity. This includes displays of affection, appearance, and same-sex relationships within the facility. Essentially, the regulation promotes respect and avoids punishment for expressing one's sexual orientation or gender identity. The sixth and final example of good practice: ending discrimination based on sexual orientation for conjugal visits of prisoners in Mexico. In July 2007, the National Human Rights Commission of Mexico announced that the city's prison system had allowed the first conjugal visit to a prisoner with a sexual orientation other than heterosexual, in line with the Commission's recommendations. In Mexican prisons, prisoners are allowed to receive conjugal visits, and most do not require the visitor to be married to the inmate. LGBTI+ persons deprived of their liberty are more likely to have been sexually victimized, reported mental health problems, experienced solitary confinement, and been subjected to sanctions. While deprived of liberty, and in prisons in particular, LGBTI persons report the highest rate of sexual victimization, including rape, as compared to other groups such as younger detainees, victims of previous sexual abuse, persons with disabilities, or first-time offenders. Their needs are multiple and interrelated, and they face specific challenges more than any other group of inmates. However, international and national standards exist for the effective, successful, and respectful treatment and management of these individuals, which need to be put into practice. Good practices exist at global level, and all states should be made aware of them and apply them accordingly.